Now we have a new speaker, Mitre Iain Edwards from UK. He's a barrister practicing out of 1 Mitre Court Building in Temple, London since 2000. His practice is divided between domestic and international criminal defense work. He worked in 3 defense teams at the ICTR in Arusha. Most recently as an advisor opposing the transfer of Jean Uwinkindi before the Rwandan High Court. He is also one of Victoire Ingabire's 2 counsel in her ongoing trial for genocidal ideology and terrorism related to charges in Kigali. Welcome to Quebec, Iain, and all the best.
Thank you, Maître Tremblay. Thank you very much. I'm going to speak briefly on the question of trials in Rwanda, in the particular context of proceedings following either transfer from the ICTR or extraditions from other countries. There is another context, which is trials that take place in Rwanda that have involved no transfer, that have involved no extradition from third countries, but which involve the application to a greater or lesser extent of international law. I'm not proposing to talk too much about that, principally because of constraints of time, but also because there is one such case that's been in the news a bit over the last couple of years. It's a case that I'm personally involved in. It's a case in which we are expecting a verdict sometime next month, we hope. And so it wouldn't be appropriate, I feel, for me to go into too much detail about it today. That's not to say that I don't have my own personal views as to whether Victoire Ingabire has received a fair trial in Rwanda. When it is appropriate, I will express those views, but you'll understand that with judgment pending, it may not be appropriate for me to do so today. On top of everything else, we anticipate that there will be appeal proceedings. I also need to be careful, of course, in talking too much about the case of Ingabire, because I do intend to return to Rwanda. It's not unknown for those who have publicly spoken out against the present regime to find themselves under arrest in Rwanda, in custody in the central prison of Kigali. I don't wish to follow in those footsteps. So, transfers from the ICTR and extraditions from third countries. A little bit of background history, perhaps, for those who aren't entirely familiar. Between June and November of 2007, the prosecutor of the ICTR made requests to transfer 5 persons to Rwanda to face trial before the High Court in Kigali under Rule 11 bis of the ICTR's Rules of Procedure and Evidence. In 4 of those 5 cases, there were actual bodies, as it were. There were actually people who had been arrested and who were in custody in Arusha. There was a 5th person, Fulgence Kaishima, who remained at large. No one was even really 100% sure whether he was alive or not, but that didn't stop the prosecutor making the application. In all of those cases, a specially designated, or in fact several specially designated referral chambers of the ICTR considered the prosecutor's requests and refused them on the basis that the chambers were not satisfied that the accused persons would receive a fair trial in Rwanda. In 3 of those cases, the prosecutor appealed. these first instance decisions, but the first instance decisions were upheld on appeal. In brief, the reasons the referral chambers refused the prosecutor's requests, they can be summarized effectively by giving you the two reasons, really. Firstly, that the referral chambers weren't satisfied that a transferred person's rights to obtain the attendance and to examine defense witnesses under the same conditions as witnesses called by the prosecution could be guaranteed in Rwanda. And secondly, although the death penalty had been abolished in Rwanda, if convicted, there was a risk that accused persons would receive life imprisonment with special conditions, that special condition being life imprisonment in isolation. And the Human Rights Committee, regional human rights courts have held that such punishment would violate guarantees against inhuman and degrading treatment and punishment. So for those two reasons, the prosecution's requests were refused. In one of the 5 cases, the referral chamber gave another reason why a person's fair trial rights couldn't be guaranteed in Rwanda, and that is that the referral chamber wasn't satisfied that the judiciary in Rwanda was sufficiently independent of executive interference. Unfortunately, what happened on appeal is that the appeals chamber overturned that conclusion on the basis that that conclusion was not open to the trial chamber on the evidence before it. That is not to say that the appeals chamber made a ringing endorsement of the fact that the judiciary in Rwanda is independent. They were simply saying that the trial chamber didn't have enough evidence to come to the conclusion that it did. And that may actually be right, because what evidence was adduced to support the defense submissions that the independence of the judiciary wasn't sufficient was pretty thin. But there it is. Right, so that's the history. On the 4th of November of 2010, the prosecutor tried again, and the guinea pig in this case was my client, Jean Uwinkindi. He had been arrested in Uganda about 4 months earlier. At the heart of the prosecution's request was the assertion that a new transfer law had come into force in Rwanda, dealing specifically with the concerns expressed by the ICTR a few years earlier. And so over the next 12 months, the defense team for Jean Uwinkindi resisted that prosecution request. We accumulated a vast quantity of material to show that the OTP's request was legally flawed, that it was factually and evidentially unsupported, and in all other respects quite misconceived. To give you some idea of the volume of material we were able to collect in support of our position, our filing came to about 750 pages. Now, I know that lawyers do have a reputation perhaps for being a little long-winded. Some may accuse us as a species of sometimes confusing quantity with quality, but the material that we put before the trial chamber was good stuff. It was powerful, unanswerable evidence from well-respected sources, Human Rights Watch, Amnesty, BBC, Professor Philip Regents, Professor Philippe Sands QC, to name but a few. Well, it all came to nothing. The referral chamber was not persuaded by our arguments for various reasons, and the prosecution request was allowed.